Some biases we are aware of, and others we might not be fully aware of, which is why they are called implicit or unconscious bias. No matter how unbiased we think we are, our brain or hardwired to make unconscious decisions. We look at others and filter what they say through the lens of our own personal experience and background. Because we all do this, we often view life and evaluate evidence in a way that tends to favor people who are like ourselves or who have had life experiences like our own. We can also have biases about people like ourselves. One common example is the automatic association of male with career and female with family. Bias can affect our thoughts, how we remember what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, we're being asked to make an important decision in this case. You must, one, take the time you need to reflect carefully and thoughtfully about the evidence. Two, think about why you're making the decision you're making and examine it for bias. Reconsider your first impressions of the people and the evidence in this case. If the people involved in this case were from different backgrounds, for example, richer or poorer, more or less educated, older or younger, or of a different gender, gender identity, race, religion, or sexual orientation, would you still view them and the evidence the same way? Three, listen to one another. You must carefully evaluate the evidence and resist and help each other resist any urge to reach a verdict influenced by bias or against any party or witness. Each of you have different backgrounds, and will be viewing this case will have your own insights and assumptions and biases. Listening to different perspectives may help you to better identify the possible effects these biases may have on decision making. And four, resist jumping to conclusions based on personal life experiences, generalizations, gut feelings, prejudices, sympathies, stereotypes, or unconscious biases. The law demands that you make a fair decision based solely on the evidence, your individual evaluations of that evidence, your reason and common sense, and these instructions. When you return to the jury room to discuss this case, you must select a jury member to be foreperson. That person will be in deliberation. In order for each juror must agree with that verdict. Your verdict must be unanimous. You should discuss this case with one another and deliberate with a view towards reaching agreement. If you can do so, but you should not surrender your honest opinion simply because other jurors disagree or merely to reach a verdict. A single verdict form for each count has been prepared for your use, and when you have finished your deliberations and have reached a verdict as to a specific count, the foreperson should mark the appropriate choice on the form with an X, and then date and sign the verdict form, filling in the foreperson's juror number on the indicated line, and then signing the foreperson's name on the second line. And just so you know, forms look like this. So there's very little to add, just an X, your juror number of the foreperson, and the foreperson's signature. The order in which the guilty and not guilty choices appear on the verdict forms is strictly alphabetical and should not in any way be considered as indicating which choice is the correct choice. When all the verdict forms are completed, the forms should be placed in the provided envelope, sealed and given to the deputy who will convey the verdicts to the court. At a time designated by the court, your verdict will be read out loud in the courtroom in your presence. During your deliberations, you must not let bias, prejudice, passion, sympathy, or public opinion influence your decision. You must not consider any consequences or penalties that might follow from your verdict. You must not be biased in favor of or against any party or witness because of his or her disability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Your verdict must be based solely on the evidence presented and the law that I give you. Your like or dislike of any witness, attorney, or party should not have an effect on the outcome of the case. The state of Minnesota and the defendant have a right to demand, and they do demand, that you will consider and weigh the evidence, apply the law, and reach a just verdict, regardless of what the consequences might be. You must be absolutely fair. Remember that it is fair to find the defendant guilty if the evidence and the law require it. On the other hand, it is fair to find the defendant not guilty if you are not convinced of his guilt beyond a reasonable doubt. Now, members of the jury, the case is in your hands as judges of the facts. I am certain that you realize that this case is important and serious, and therefore deserves your careful consideration. W. You swear that you will keep these jurors together separate from all other persons, and that you will not allow anyone to communicate with them or overhear their deliberations, that you will not make any comment to them about the law or the facts in this case, and that you will not disclose to anyone except this court anything which you may learn from their deliberations. Members of the jury, you're going to go with the deputy now back to your usual role, including jurors 96 and 118. You, however, will be diverted to my office. You are our alternate. Will not be a part of the deliberations, but I would like to talk to you a little bit. So you can go with the remainder of the jury, but follow the sheriff deputy instructions. All rise for the jury. We're still on the record. All right, a couple things. I know the defense was in the process, I think, of making expressing a concern or an objection to counsel's argument for belittling the defense. Is that what I correctly perceive that objection? I think we dealt with it sufficiently during the objections during the rebuttal, so there will be no additional instruction in that regard.
I do believe that it constitutes prosecutorial misconduct and is potentially basis for grounds for mistrial.
Okay, I think these were nonsense. What you're talking about originally.
I do, Your Honor, but then in rebuttal there were repeated comments about how we were, and implications that we were taking was one example, that we were creating Halloween stories was another example, that these were stories, and that was a repeated comment, saying that we misrepresented facts and put words into Dr. Mazur's mouth, that we made several statements that they put forth as stories. After the court instructed him to use stop using word stories, he clarified that it's just fabricated facts. And so there were multiple references to that, that we were stating the truth. Right? I mean, and again, so multiple objections. This is essentially governed by State versus McDaniel. The final argument to the jury of prosecutors governed by a unique set of rules, which differ significantly from those governing counsel in civil suits, and even those governing defense counsel in the very same criminal trial. Special rules follow directly from the prosecutors and the unique role in the criminal justice system, which mandates that the prosecutor not act as a zealous advocate for criminal punishment, but as the representative of the people in an effort to seek justice. For example, that when a prosecutor argues that a defense is meritless, he cannot belittle the defense either in the abstract or suggesting that the defense was raised because it was the only defense raised. So there's lots of law in this, Your Honor, that essentially these comments, repeated comments, constitute prosecutorial misconduct.
For the record, that time, the first objection was to Black will use the word story because it was isolated and in its context did not seem to me to be belittling. However, the continued use of it, I did sustain the ultimate objection that counsel made to the use of the word stories and instructed the jury to disregard it. Also on shading the truth, that I sustained the objection and instructed the jury to disregard it. I'm not making any findings as to whether it was the type of prosecutorial misconduct that resulted in mistrial. I think it was adequately addressed by the court's instruction to disregard it. All right. With regard to other matters we have, I think there are some bench conferences that you wanted, that are fairly historical, that you wanted to memorialize, but also a new motion based on events this weekend. Mr. Nelson.
Your Honor, as the court is aware, prior to coming into court this morning for closing arguments, we have an in-chambers discussion about events of this weekend, specifically referencing that an elected official, United States congressperson, was making what I interpreted to be, I think reasonably interpreted to be, threats against the sanctity of the jury process, threatening and intimidating the jury, demanding that if there's not a guilty verdict, that there would be further problems. And given the fact that this jury has not been sequestered, it has been my position all along the course of this case that this jury should have been sequestered at the outset. The jury has not been continually told to stay away from only media about this case. There's a high probability that members of this jury have seen these comments, are familiar with these comments, and things that have happened throughout the course of this trial. It is unfortunate that there was another situation that occurred during the course of this trial. But obviously, Your Honor, we also, as I mentioned previously too, one of the jurors does live in the city right center, as I recall.
Although I think that is the alternate we just dismissed.
I don't believe so.
I thought it was, but go ahead.
I'd have to go back to double check right now. I just think that the sum total of this trial happening in such a public context, number one. Number two, all of this media attention is profound. I admittedly stay away from finding out the respect of it, but that has required me to stay away from all of it. This case has found its way into fictional television. There were I was advised of 2 television shows during the course of the past few days that specifically involve references to this particular case and the reactions of the characters in these stories to this particular case. This jury has, despite all best efforts, has been bombarded with information relevant to this case. It is impossible to stay away from it unless you literally shut off your phone, shut off your TV, shut off your computer, and no such instructions have been given during the course of this trial.
Well, to be fair, the last few times I've advised them, I told them don't watch the news. Pure and simple.
Right, but if you can't even watch your favorite Thursday night television program and it comes up, this is the problem, right? And why I have felt that this jury should have been sequestered from the very beginning. Exactly. And so I had moved based on that, this again for a mistrial. The idea is that it's a public trial. I think the court has accomplished that. But the media attention is so profound. It is such a modern comparison, such a modern problem to have. I mean, literally, I walked from this courtroom into the courtroom where I've been permitted to stay. During the course of this trial, I've received literally thousands and thousands and thousands of emails. So much so that I don't even look at that particular email. So, but my phone gives me alerts on things that just happened, and I can't avoid it. And it is so pervasive that I just don't know how this jury, it can really be said to me that they are free from the taint of this. And now that we have U.S. representatives threatening acts of violence in relation to the specific case, it's my thoughts.
Well, I'll give you that Congressman Waters may have given you something on appeal that may result in this whole trial being overturned. What was the state's position?
The state's position, first and foremost, and this is a concern I raised at the beginning of something that's appropriate. I don't know that this particular representative made a specified threat of violence. I don't know what the context of the statement is. I also don't know what television shows Mr. Dawson is referring to in terms of any of this. So I just don't think that we can muddy the record with vague allegations as to things that have happened without very specific evidence that's being offered before the court. As a practical matter, through the jury selection process, the court is providing instructions, has determined whether or not there are any outside influences. The law presumes that the jury follows the judge's instructions, and the court has instructed the jury today that they're not to let any outside influences or public opinion sway their deliberation. The law presumes that they will be capable of doing it. So without any sort of specific offered proof or information in the record, without any specific evidence that this particular jury was influenced in any particular way, I believe that the defendant's motion should be denied. Your Honor, I make my comments in the context of this is all such an evolving situation. I'm just going to spend my weekend preparing for closing remarks. And I certainly can supplement the record with news articles. I can supplement the record with the storylines of particular shows that were brought to my attention. So I'm making it to know the record at this particular point. And I can certainly supplement.
Yeah, you can supplement the record with whatever media reports. I'm aware of the media reports. I'm aware that Congressman Waters was talking specifically about this trial and about the unacceptability of anything less than a murder conviction and talk about being confrontational, but you can submit the press articles about that. This goes back to what I've been saying from the beginning. I wish elected officials would stop talking about this case, especially in a manner that is disrespectful to the rule of law and to the judicial branch and our function. I think if they want to give their opinions, they should do so in a respectful and in a manner that is consistent with their oath to the Constitution, to respect the co-equal branch of government. Their failure to do so, I think, is abhorrent, but I don't think it has prejudiced us with additional material that would prejudice this jury. They've been told not to watch the news. I trust they are following those instructions, that there is not in any way a prejudice to the defendant. Beyond the articles that we're talking specifically about the facts of this case, a congresswoman's opinion really doesn't matter a whole lot. Anyway, so motion for mistrial is denied. With regard to, there was a report that counsel were made aware of a few days ago that a juror may have been talking to a major media outlet. We checked with that major, it appeared right from the beginning that it was literally an hearsay telephone game. That media outlet, in fact, took it very seriously, did a nationwide contact of all of its reporters and staff. You check on the veracity, and their veracity is none whatsoever. Nobody from this major media outlet made any contact, and I find that incredible. And so just for the record, I pass that along. Now, I think we still have the memorialization, but we also have to talk about a blanket waiver.
Yes, Your Honor. So a couple of things. In terms of the memorialization of sidebars and objections, we had previously provided
mistrial. They tried to go for a mistrial. That's crazy. Wow, they tried to go for a mistrial. No mistrial for you, buddies.
To include just essentially a stipulated pleading.
11 minutes. 11 minutes, they'll be done.
The only thing that you need to reserve for appeal is what the objection was and what the court's ruling was. So I would encourage both parties to get together and figure that out and file it reasonably quickly. It doesn't have to be today, tomorrow, or even the next day. But just to get out of while our memories are fresh.
This was George Floyd, y'all.
I was expecting that we're going to be able to come up with a stipulated document, but if there's anything that needs to be set out, we can just indicate our contrary memories about it.
Absolutely. I think that would be the best way to memorialize this in any case. All right. Other than Blakely, do you have any other issues to make a record of?
I think we just need to have some administrative discussions about questions, timing.
Jury deliberating.
All right, so what are your Blakely?
I have not yet had Mr. Trouble execute the written waiver. Again, I do have the printed to get that taken care of. But I can do it orally without. So Mr. Chauvin, take the mask off. Mr. Chauvin, you're aware that during the course of these proceedings, the state has filed what's called a blatantly notice or a notice to seek an aggravated sentence, correct? Yes. I have explained to you the bases on which the state is seeking to have an aggravated sentence imposed on in the event of a conviction on any one of the counts here, correct? Correct. We discussed those, and I have specifically advised you that you have a right to have a jury decide whether or not the state has proven those grounds for an aggravated sentence beyond a reasonable doubt. You have a right to have a jury decide if you violate it, right? Right. And I've advised you that the state has to prove those grounds beyond a reasonable doubt. Right? And we can waive that right and allow, if you're convicted, we can waive your right to a trial and allow the judge to make those determinations. I advise you about that. Right? Now, do you want the jury to make a decision about the proof required for the aggravated factors if there's a conviction, or are you willing to waive your right to a trial on those matters and allow Judge Cato to make those decisions? I don't have to waive it. Have Judge Cato decide on those issues.
Mr. Chauvin, again, I'm going to address you individually because this is another one of the decisions you have to make for yourself. This is a waiver of your jury trial right when it comes to aggravating factors. Normally, we would submit a verdict form with interrogatories with a question, yes or no options. And that's what generally the jury would consider. In order to say yes, the jury would have to be convinced beyond a reasonable doubt. The burden of proof did not change. It's only now going to be the one who's answering those yes or no questions. It was always true that based on whatever the answers are to those, that I would be the one deciding if they constitute legally substantial and compelling circumstances, then we would expect briefs from both sides on that. Do you understand that? So basically, I would be answering those verdict form questions instead of the jury and applying the standard of proof beyond reasonable doubt. Is that what you want to have happen? All right, I would ask that you file a likely waiver in addition. All right.
Yeah, I just have a question on the form that was provided. It's an administrative question.
Right, it's an administrative memorialization, so you can do that afterward. All right, counsel, I'm going to talk with we basically give instructions to the alternates, give me 20 minutes, and then once come on back. All right, otherwise we are in recess until we hear from the jury.
All right, so that ends case of chief both parties. In the case of Minnesota versus Derek Chauvin, the jury has now taken the case. They're going into their deliberations. They've been deliberating now for 15 minutes or so while the court dealt with some issues. Towards the end there, you saw the defense asking for a motion for mistrial. They've been dancing around that issue throughout the trial. Once again, the judge decided to deny their motion for a mistrial. We'll get into the specifics of that in a minute. What you saw at the end there was a blatant waiver being accepted or being exercised by Derek Chauvin. What that is essentially, there are aggravating factors in this case, which allows the judge to sentence beyond the recommended sentences for these particular charges. Whatever he's ultimately convicted of, he will then be charged higher. And let's say for second-degree murder, the recommended sentence is 12 and a half years. The judge can go all the way up to the maximum of 40 years. And we'll talk about aggravated factors, blatant waivers, and the motion for mistrial and everything that went on today. When we return, we're going to take a quick break. When we come back, we'll go out live to Minneapolis for that and more. So stay with us right here.
Oh, that's really it.
attention of anyone on Medicare. You may now be eligible to save over $1,700 per year and get additional Medicare approved benefits, including free hearing aids, free eyeglasses,
So they tried to go on this side. That's funny. Cause I thought it was gonna slide off into the sunset with the mistrial. What's up? Well, what's going on?